Welcome back to the Fleeting Conversations podcast. I'm your host, Matthew Leffler, the armchair attorney, and I am so excited for this episode. This episode specifically, you are going to be in for a treat. You see, as some of you may know, I go by the moniker the armchair attorney, and I am, in fact, a lawyer, but not often do I get a chance to talk to real-life lawyers in the supply chain space. And in just a few minutes, we'll be joined by Brandon Wiseman, who's the president and founder of Trucksafe Consulting. He is a lawyer with the Childress Law firm, and he is also a technology software, entrepreneur, founder, a company called eRegs. We're going to learn all about that in just a few minutes. Now, all of this is possible through you, the viewers and the listeners who find value in the things we bring to you on a semi-regular weekly basis. We kind of do it as we see fit. It depends on the schedules of our incredible guests, but I cannot thank you enough for tuning in for these things when we put them together. Whether you're watching this on LinkedIn or Twitter or YouTube or Facebook or anywhere else you might find your audio podcast, we are grateful for your support. We are also grateful for the support of our friends over at DAT. Dial a truck, DAT. It's in the freight. We have some great announcements to talk about very briefly with you today about what DAT has going on for you right now. If you're a motor carrier and you have a subscription to DAT, great news for you. The initiative right now is called Gear Up. And what's happened is your subscription to DAT has been automatically upgraded to the next level tier in DAT at no extra cost to you and absolutely no strings attached. This will go through October 23rd and October 24th. All of your accounts will revert back to the initial tier you subscribe to, but this way you get a little peek at what's available to you as we gear up for peak season. And what a peak season it's shaping up to be. In addition, Journal of Commerce Inland Distribution Conference is taking place September 30th through October 2nd of 2024. I will be attending the Inland Distribution Conference, and in fact, I will be speaking about things like post-employment restrictive covenants. Non-competes is the name of the game. And in light of the FTC's proposed rule to ban non-competition agreements, as well as the U.S. Chamber of Commerce suing to stop the ban on non-competition agreements, and in addition to Chevron being overturned. Oh, if you are a shipper, if you are a motor carrier, or if you're a broker, if you're literally any working American, you might want to check this out, because 1 in 5, 30 million Americans have some form of non-competition agreement. And it's important for you to learn what these things are all about. Chances are you have a non-compete or a non-solicit or a non-disclosure. At a minimum, you certainly know somebody who has one. And the best thing for everybody when it comes to post-employment restrictive covenants or perks is that you want to understand what the perk is that you're seeing, how to deal with them, how to negotiate them, how they're enforced. These are all very important things that you will learn at our talk at the Inland Distribution Conference, just a few short weeks away. And of course, this is brought to you by the floating disembodied head of me, myself. Hello, head. Always a pleasure to have the floating disembodied head join us when we get ready to talk about all the things that happen when good carriers go wrong. Now, earlier this week, I had a chance to do a little bit of a deep dive into a big-ish case of a motor carrier who has gone bankrupt in Illinois. This company was called Blue Thunder Trucking, and they went into Chapter 7 bankruptcy. They had a couple other names within their doing business as. And one of the things that was so interesting, I'll put this up here so you can see, but prior to the closing of this trucking company, they had been inspected by DOT and safety officers 65 times. And in that 65 times of inspections, 28 of their commercial vehicles were put out of service. That's 43.1% out of service. That should concern everybody. This is the nature of our industry. But did you know, and I hope you do, that the average out of service rate for equipment in the United States for, commercial vehicles hauling freight interstate is 20%, actually slightly over 20%. Again, 1 in 5 commercial vehicles on the road right now are unsafe at any speed. That means that people aren't maintaining their equipment properly, and there's an out of service rate for equipment that's always seemingly 20%. That can't be good. But the reality is, if you're running a fleet and you're having problems with your vehicle maintenance or your hours of service or your driver qualification, you're one step away from intervention. And when you get to intervention status, things get tough. Insurance may be hard to procure. It might be difficult to find shippers willing to tender you freight or brokers willing to work with you. And if you're in the place of when things go wrong, what do you do? Well, I have a treat for you because I have the guy that you call when things go wrong. And I'm so excited to welcome back to the program, friend of the show and fellow lawyer, Brandon Wiseman. Brandon, welcome back to the show.
Hey, Matt. Thanks for having me back. I feel like I'm always at the opposite end of the spectrum from you in terms of our wardrobe selection.
I appreciate that you made time to come in today. I think you're keeping a little bit more muted. I like to be a little bit more festive. It's Friday. You can't take that away. We're one day closer to Monday. How have you been, my friend? What's new and exciting in your world?
I've been great. Yeah, everything's going great over here at Trucksafe and Childress Law. Keeping busy as always. I can't complain.
Well, I mean, let's talk about things we can complain about, which is the FMCSA and the regulatory structures around us. Now, you and I are old hats when it comes to the compliance aspect of trucking, but what has gone on in the last month or two that has kind of got your attention? I'm thinking Chevron, but what are you thinking?
Well, we could certainly kind of put Chevron to the side because I know we've got a lot to talk about there. In terms of kind of agency developments, not a whole lot in the last month or so. This is an election year. And so as you typically see in an election year, the agency tends to wind down what they're doing towards the election. Just because, when somebody new gets into office and they start appointing new FMCSA administrators, for example, then the new crew is going to have their own agenda, and they may go back and unwind everything that was done leading up to their appointments. So for that reason, you don't see a whole lot of regulatory developments during this time, and so that's kind of the era that we're in right now. There are some things kind of simmering in the background, one of which is a potential change to the way that we give carriers safety ratings, safety fitness determinations. In my view, that's probably the biggest thing that's outstanding right now. In fact, FMCSA has been holding some listening sessions on that topic, and I attended one earlier this week, and it was, it was insightful. Nothing crazy came about in that listening session very early in the rulemaking process for that. But that's kind of what I'm watching at this point.
Well, I remember I attended an IANA event earlier this springish summertime, and the FMCSA had a representative there to talk about a bunch of different things, but I was really curious about speed regulators. And so we've had the FMCSA when they first kind of came out and said, hey, we're thinking about regulating speed for every motor carrier. They put initially 68 miles per hour. That was very rapidly walked back, and they said, well, we don't really have a number in mind.
Yeah, that person got fired.
They disappeared. They're on another project. We've deprioritized the number. But do you expect to see something around speed this year, or is that going to be
definitely not going to be this year? We know it's not going to be this year because the FMCSA, DOT more broadly, publishes their regulatory agenda every once in a while, and we've seen this particular can kicked down the road for a long time, going back to 2016, I think, and we most recently saw them kick the can down to next summer, I think, is when so summer of 2025 is when they are now saying they may revisit the topic. So I don't expect to see anything on that anytime soon.
It's interesting because I was talking to some folks through the interwebs about this speed regulation aspect, and one of the things I find fascinating is when the ELDs were mandated, and eventually there was some litigation, but eventually that rule won out. One of the things we saw kind of as an ancillary piece was that smaller motor carriers who had been using paper started to speed more. We saw more people going faster. And so this question of does the ELD mandate actually drive safety? What are your thoughts about, like, how does ELDs play with potentially speed regulation? Is that the final step in making this presumably supply chain safer, or is it just another aspect of why it's tough to be a truck driver?
Yeah, I'm a little skeptical at this point that more regulation is the answer. I think FMCSA has started to look at the data from the ELD mandate and trying to figure out whether it's doing what they expected it to do. And my perspective on that is, when you really drill down to what it is that the ELD mandate is supposed to do, it is supposed to cut down on log falsification.
Mm-hmm.
And so what you see, it's easy to look at the enforcement data and say, well, we're seeing more log falsifications now than we ever have before, which is generally true. And so isn't that an indication that the ELD rule is not working? And from my perspective, no, that's not the answer. That tells me that it is working.
Yeah, you're catching more
that
people.
We're catching more people in the act of falsifying their logs, whereas with the paper logs, it may have been a little bit more easy to conceal hours of service violations. And so I think in that regard, ELDs undoubtedly make it a lot easier to catch drivers in the act of falsifying logs. Not just drivers, carriers too, nefarious carriers that are trying to skirt the rules. And in my own anecdotal experience, it's so much easier to get control of those issues with electronic logs. Now, whether the idea of catching log falsification is also tied intimately into the idea of trying to minimize the occurrence of fatigue driving, because fatigue has historically played a big part in highway accidents. And so if we cut down on log falsification, the idea is that maybe we cut down on fatigue driving, and then ultimately we get to what we're trying to get to, which is a reduced number of crashes. I don't think the data has played out yet in terms of whether the ELD mandate has been effective at reducing fatigue-related incidents, but we're still fairly early into it. A lot of folks, it kind of seems like it's been forever since we've had these devices, but they've really only been mandated across the board since 2019. So we're in the 5th year now of them being mandated for pretty much all drivers. There are still certainly some categories of drivers that are exempt from the rule. So I think we need to give it a little bit more time and see. But there are some, as is true with any regulation, there are going to be unintended consequences when you pass a rule. And whether the ELD rule had an unintended consequence of increasing the number of speeding events, maybe so. I don't know that I've seen compelling data on that point. But yeah, that's the risk you run when you have agencies like this, passing these laws. You try and minimize that as best as you can through the rulemaking process and the comment notice and comment period. And you're hoping that people will submit data to show that may be a possibility, but it doesn't always play out like that. So, that probably takes us into the Chevron discussion.
Well, we'll get to Chevron in just a moment, because I want to pick a little bit more on the ELD piece. This is a thing that I found fascinating for me, and I've learned over time more about this so-called self-certification process for ELDs. And I made a comment when I was talking to that same FMCSA representative at IANA around self-certification. So for those who don't know about this, when the federal government through the FMCSA mandated ELDs, they didn't mandate specific ones they were going to endorse. That wasn't their position. But what they did was they said to manufacturers, fill out this form, certify that it can do the things we require it to do, and then you can go sell them. And we'll have a list on our website of people who have passed this self-certification process, and we'll have another list of revocations of these devices that are out there. Last month, it might have been, last month, because today's August 2nd, but last month there was 4 ELD providers, devices that were pulled off the market. And if you look at the data on the FMCSA's website, there's about 1,000 ELDs that are currently like, these are going to be good. These ones have satisfied our self-certification. And there's 220 or so ELDs that have now been revoked. And I'm kind of curious, like, what do you think? for me, I want to see self-certification go away, but you practice in this space every day. You have probably a better perspective, but what do you think about that?
Well, I think it's the most pragmatic approach to tackling this problem that the FMCSA could have taken. First of all, when you look at the list of self-certified devices, and in particular the ones that have been revoked, it's important to keep in mind that the majority of those revoked devices were voluntarily revoked by the manufacturers of the devices. In fact, I think there are only like a dozen or maybe a couple dozen that have been involuntarily revoked by the FMCSA, meaning that the FMCSA has investigated them and found that they shouldn't have been self-certified as compliant with the technical specifications to begin with. The vast majority are voluntarily revoked, which usually happens when the manufacturer either goes out of business or if they come out with a new model that they want to sell and they're no longer going to support the old model, then they voluntarily revoke their old model. So that's the majority of what you're seeing on the revocation list. But in terms of kind of your broader question of whether we should move towards an FMCSA type approval process, my hesitation, Canada has something like that.
Yeah, I was going to mention that.
Canada had that. They were a couple years late to the ELD mandate. They came out with theirs a couple years after the FMCSA, and one of the big reasons that they waited is because they decided to go a different direction with the certification process. In order to have an ELD, a compliant ELD in Canada, it has to be certified by the country's government that regulates commercial trucking in Canada. And, as you would expect, that brings its own set of problems, and they are problems I just don't think the FMCSA is well equipped to handle at this point. FMCSA, I've said this over and over in other contexts, but the FMCSA is a relatively small agency. They've only got at any given time around 1,000 employees. And those 1,000 employees are charged with regulating over 700,000 trucking companies in the U.S. And what we know from that is that they just can't keep up with the workload. They can't even keep up with their main mission of auditing carriers and assigning them safety ratings. That's one of the reasons why they're thinking about changing up the way that they do safety ratings. And if they don't even have the manpower to be able to do that core function, then they're certainly not going to have the manpower to be able to go and now essentially regulate, historically non-regulated entities, manufacturers of these devices. But at the same time, you could see why you would want that, because you run the risk with the self-certification process, obviously, of folks getting into the market that shouldn't be there. They have not done the diligence to make sure that their product is up to par, and so they end up certifying that their device is compliant with the technical specs, and it's really not. And then the carriers purchase those devices, and then they turn out that they're not compliant. And that's obviously a problem for everybody involved. And so you don't want that. But with that said, I think what we've seen is, the leaders in the ELD technology space, they've got a pretty big market share. I think if you would look at that if you look at the data. And so I think my recommendation always to motor carriers that are looking for an ELD solution is, let's stick with the big names out there. It may cost you a little bit more, but at least it gives you some peace of mind that you're not going to run into a compliance issue going forward. Yeah,
that's the thing that I kind of harken back to. I think you're exactly right as like, what are the challenges the FMCSA can do right now with what they're working on, and they're understaffed to solve a lot of issues. And having the FMCSA in charge of some sort of certification process, that's outside of their core competency. And my big concern, not just as a device that doesn't meet the specifications to get revoked later on, but like, what are the data security elements that are required for these devices? And everyone who's out there, they raise some great money through VCs because now the government has mandated a new SaaS product, and you get this provider who says they can do it. Truckers don't know necessarily how to buy technology like that, and they go with the one that's either doing the best SEO to get them to come to the website and buy it. So I guess like I go back and forth. In my heart of hearts, I really do believe there should be a process where the FMCSA is saying this is safe for the market, and we've done our own investigation because it is so important for safety.
Yeah.
But they don't have the bandwidth, they don't have the resources, and that becomes this problem we're going to likely continue to see.
Yeah, I suppose what they could do is what I understand Canada has done, which is commission a third party or multiple third parties to serve as their certifying arm. You know, they have a contract with FMCSA, and then they get paid a certain amount of money, and then they are the body that certifies the devices. I think that's the way to do it, one way of doing it, and certainly the FMCSA is toying with this because last year in 2023, I think it was early in 2023, FMCSA published an advance notice of proposed rulemaking about potential changes to the ELD rule, one of which is, hey, should we move away from a self-certification type system? And, that's stuck in the ANPRM process. We haven't seen it move forward. It may move forward next year. I don't know. But, clearly they're thinking through that. And I think that's probably one way that they could address it if they wanted to go that way is somehow commission a third party or multiple third parties to do that testing. The other downside to that, of course, is if you look at the number of devices that have been certified in Canada versus the ones that are self-certified in the U.S., it's a lot fewer in Canada, as you would expect.
Yeah, exactly right.
And so you end up with fewer options. Now, to some extent, that's a good thing because that means we're weeding out the non-compliant devices. But on the other side of things, it minimizes the number of available options, and then can jack up your prices for the truckers and that type of stuff. So.
That's such a great segue of like raising the barriers to enter. So we talk about that with devices, but I think about raising the barriers to enter in trucking generally. So as of right now, I think it's the Motor Carrier Act of 1980 established like the insurance limit. The motor carriers that are hauling, dry goods across the country, minimum insurance is $750,000, hasn't been adjusted for 44 years. Do you think it's time? Should we have that go up? Because that's another thing that I'm also very interested to think of. What should insurance rates look for motor carriers?
Yeah, it's probably time. I mean, obviously insurance is just one small component of the barriers to entry. We can also talk about things that the FMCSA has toyed with, like should we have some kind of a knowledge exam that we test new entrants on their knowledge about the regulations before we issue them a license to operate. So there's several different things that we can look at in terms of the barriers to entry. But in terms of insurance specifically, I mean, that's right. The insurance limit hasn't changed since the 80s. It hasn't even tracked with inflation. And what we know from the highway accidents that we're seeing more and more, that the litigation stemming from those accidents more and more prominently, is that the jury verdict sizes aren't going down. That's for sure. They are skyrocketing. And so insurance, it's just, even for relatively minor injuries nowadays, the minimum insurance that is required of carriers is just usually not sufficient to cover any significant portion of the damages sustained in those accidents. But, I'm always kind of looking at both sides of this. On the other side of things, carriers are already struggling with the cost of insurance with the limits as they are right now. And so if we talk about raising the limits, I've heard talk of raising it up to $1 million, $2 million. We've seen some states jump the gun on this. New Jersey has went out on its own and raised its minimum for commercial motor vehicles for carriers operating in New Jersey up to $1.5 million, I think. Yeah. But if we start talking about that, then cost of insurance are necessarily going to have to go up with that. And so whether the market can bear it or not, I think is a question we need to be asking.
I think that I'll give an anecdote because I in a past life, I was a defense attorney for trucking companies dealing with these catastrophic accidents. And I remember vividly a motor carrier who had the $750,000 policy. Through an inadvertent act of omission, he kind of changed lanes without really looking and hit a young woman in a Mustang. She smashed into a telephone pole, had really significant injuries to her pelvis, and one of her legs got broken, among other things. And the verdict ultimately was around, I'd say maybe $850, close to $900,000. And the motor carrier, like the insurer, tendered the policy. So this is a normal thing. For those who are watching, if you have an insurance policy limitation and your insurance company's like, yeah, we know liability is going to be there, they'll continue to defend you. and then they will tender the policy and say, here's the full amount, and we're done with our liability. And I remember talking to the owner operator, and he said, well, what happens now? You've tendered the policy. What happens to me? I go, the rest of that money is coming from you. They're going to lien your truck. They're going to lien your house. They're going to go after your bank accounts. They will take whatever they can. And my advice would be to consult with a bankruptcy attorney who can help you figure this out. So this point that you make is so well taken, because it is difficult to be a motor carrier. It is not an easy business. It's never been easy. And the margins you operate on are so slim. And today, even more so than it has been, during the COVID boom. And they don't have the bandwidth to get more insurance. So you have these accidents that take place where the ultimate loser in all of this, besides the victim, who is certainly on the hook for a lot of troubles, is society generally. How do you get these people to be covered? I mean, they have to go through some other process. I think this is why we see brokers get tagged more often in litigation, because maybe they have insurance. But it's this really delicate walk that we have to have, which is, how much do we want the vehicle to be insured for? And is that enough to cover the things that might happen otherwise?
Yeah, and it disproportionately affects the smaller trucking companies, right? Because the larger ones, if they're not self-insured for the minimum amount, then they're not going to be the ones that are struggling to pay the insurance cost with that. It's going to be the smaller trucking companies that just can't afford to pay the premiums for anything more than $750,000 that are going to suffer from this. So, yeah, I think there's a lot that goes into that conversation. That's probably exactly why we haven't seen it increase at all in the last 40 some years. But we've seen attempts to, Congress is always toying around with some kind of, legislation that would mandate it. That never seems to get any traction. So it's one of those things that we're just going to have to wait and see if anything happens. I think one thing that needs to factor into the conversation is some level of tort reform. We've seen this pop up in some states, Florida and Texas most recently, I think. But, this is certainly not every case, but there are certainly a lot of cases against trucking companies that aren't legitimate cases. The trucking company wasn't even at fault.
Yeah, that's right.
Almost admittedly in the case, and they end up with, multi-million-dollar settlements. Or
joint and several liability is a very dangerous phenomenon.
Yeah, and so, and it's leading to this situation, we call it social inflation, where the higher the verdicts get, the more prominent these cases are. I mean, for example, we had $1 billion case in Florida a couple years ago now against a couple of trucking companies. The more and more the news gets out about these multi-million-dollar and billion-dollar cases, it just desensitizes the public to these huge numbers, where if you're a jury member now and you've seen news about $1 billion verdict, what is $200 million anymore? It's this concept of social inflation. So I think we need to have some conversations about some kind of nationwide tort reform to address some of these outlier cases and factor that into the analysis.
I love how you've teed that up for me, because I look at these different pieces and how do they fit together. So we talked about insurance being minimum $750,000. Talk about the FMCSA not having the resources to regulate all the trucking companies that are out there, all these things that are happening simultaneously as we watch verdicts rise and rise and rise. I would love to kind of get your thinking on vehicle maintenance specifically. So this is one of my favorite topics to dive into, because I think most Americans have no concept of the safety of the equipment on the highway right now. And I remember talking, again, the FMCSA when I was at IANA, about vehicle maintenance. And the story that is told from my perspective is, we as a regulator believe that we want to eliminate all roadside fatalities. That's impossible, but we're going to try our best. And we think the most problematic issues when it comes to catastrophic accidents are driver fitness, driver qualification. Vehicle maintenance is kind of ancillary. We haven't seen a lot of fatalities as a result of vehicle maintenance. But for the folks who are watching at home who are not familiar, because you know the numbers, that's why I love having you here. 1 in 5, 20% on average of every commercial vehicle on the road at any given moment, if it was inspected by a DOT officer or anybody who's trained in this, would say that truck or that trailer needs to stop. It needs to go away and get fixed. It's not safe.
Yep.
And I liken it to going to the grocery store and buying milk. And I say, I want to buy a gallon of milk. There's 5 gallons available. And someone says, Matt, just so you know, one of those gallons is unsafe. And it's like, well, which one is it? And like, we're not going to tell you. It's like, what other industry has that level of really, really bad maintenance? So what are your thoughts on the vehicle maintenance side of this industry that I find so absolutely fascinating?
Yeah, it's crazy. I don't have much else to say about it. It is a high number. Yeah, you're right. I think the national average is 22%, a little over 22%. Out of service rate for vehicles, and then like you said at the start of the show, the carrier that was shut down had like a 41% out of service rate. I see a lot of carriers across the country that are flirting with disaster when it comes to their maintenance programs, and you do see cases pop up where it's not the driver history that was a problem or the driver's qualifications, it was maintenance problems. Especially when you see like rear end collisions and they start digging into the brake testing and on your commercial motor vehicle, whether you did the proper test on the brakes, was it able to stop in time or not, and that type of stuff. So it's a big exposure for sure. And there's a lot of excuses that go around.
It's hard to do. That's the biggest excuse. Or it's expensive.
Or we have an independent contractor fleet, so we can't force our independent contractors to do the maintenance. Spoiler alert, you can force them to do it, and you better force them to do it.
That's right.
Because that's going to be your bigger concern. I don't, comparatively speaking to your reclassification risk, So in any event, lots of excuses, just not enough fleets even understanding what these metrics are telling them is what I've found over the years. It's, you can't fix what you don't measure, right? And so if you aren't measuring your compliance in these areas, if you don't understand what the metrics mean, then how are you ever going to get control of these things? You're not going to. So you need to watch your metrics. You need to figure out what are the trends. When it comes to maintenance, it's usually one of two things. It's either you're not holding your drivers accountable to their pre-trip inspection obligations, and so your drivers are just pencil whipping those things, and then they end up out there with a taillight burned out. Very common, obviously.
Yeah.
Or they're operating on tires with low tread depth. All things that should have been caught in a pre-trip inspection that weren't. And, you carrier, you have no excuse for that, because, you should be holding your drivers accountable to that. And if you're not, then you're equally culpable for that. So that's usually a big part of it. And then also, the true mechanical issues, things that are more latent that maybe a driver couldn't discover in a pre-trip inspection, but should have been caught in a DOT annual inspection, for example.
Yeah.
And doing those inspections more frequently than annually, is probably something. I know you and I have had that conversation before.
Absolutely.
Should we move to something like California that has a 90-day vehicle inspection requirement? I don't see us moving to that anytime soon on a nationwide level. But a lot of fleets do it voluntarily across the country, a lot of the bigger fleets primarily, if not 90 days, semi-annually or something like that. Just making sure that a qualified mechanic is looking at the vehicles and the trailers more often than annually seems to be something that drives their numbers down. So
you've outlined this perfectly. I mean, what I look at this is, on the one hand, you have industry saying we're overregulated, the verdicts are too high, we need tort reform. On the other hand, you have underinsured motor carriers, because 750 is spoiler for any motor carriers that are watching. If you have the minimum, like, it is like 4 or 5 days in the hospital and you've exhausted that amount. Like, I'm telling you, you will go bankrupt if you carry the minimum and something catastrophic happens, especially in a state that has joint and several liability, where you can be partially on the hook and still be responsible for the entire damages. So
not to mention the legal fees, some of that going to the legal fees. So.
Absolutely. Well, the duty to indemnify is one thing. The duty to defend is another. And you can pull from different buckets to an extent. But I would say you have an industry that is, generally speaking, not maintaining its equipment properly. So poorly maintained equipment, coupled with very low amounts of insurance. And we ask the industry, is this acceptable? Is this the thing we want to see? And I think you teed it up really, really helpfully, is how much does the federal government actually require you as a motor carrier to keep your equipment compliant? And that is federally mandated, one inspection a year. One qualified mechanic looks at your truck legally is all that's required. And you can do anything else you want to do in the interim. But most for hire motor carriers of scale would never do that. They would never inspect it once a year. They touch it more often. Do you think, or have you heard any rumblings within FMCSA of requiring 2 inspections a year? Is that asking too much, a bridge too far?
I haven't heard anything about it. It's certainly not on the regulatory agenda, and I haven't even heard any rumblings about it. So, yeah, I don't see it happening anytime soon. Would it be a good idea? Possibly. If you know anything about the regulations, the Federal Motor Carrier Safety Regulations, if you're in those at all, then you'll realize pretty quickly that the maintenance section, as compared to other areas like drug and alcohol testing and driver qualification and those types of things, is the shortest section of them all. I mean, there's not a whole lot that goes into vehicle maintenance from a regulatory perspective. You're right; it's the annual inspection requirement. You got to use qualified mechanics to do those inspections. You got to have qualified mechanics to inspect your brakes. You got to have some record of your preventative maintenance, but not a ton. And you got to have your driver inspections, and you got to have them document those correctly. And that's really all that there is to it. And so is more regulation the answer? I don't know. Like I said at the start, I'm never been a huge fan of more regulation. I rarely see it go the way that the agency initially thought it was going to go. And, but I'm always open to hearing some proposals if there's data to support that a new regulation might actually do something to bring those numbers down, but I just haven't seen it yet.
I would love to see if there could be research done on this question about motor carriers that are doing 2 inspections a year. What's their safety and maintenance rating versus the ones who aren't doing it that way?
Yeah. It wouldn't be too hard to do. I mean, there are several motor carriers, even just anecdotally, a lot of my clients are doing more frequent inspections than annually. And I could tell you anecdotally that a lot of they all, relatively speaking, have pretty low vehicle out of service rates. And whether it's a 1-to-1 correlation, hard to tell. But I think that kind of study would be important, and it doesn't seem like that would be that heavy of a lift.
Yeah, I think that if we were to do something like that, I think that the conclusion would likely look similar to if you do more than 1 a year, if you do them at a 6-month cadence, or even for trailers, a 9-month cadence, like there's ways you can experiment. But if you're an LTL provider and you're asset based, more likely than not, you're touching every commercial vehicle at least 3 times, probably 4 times a year with a qualified mechanic. There's just no way around that, how they use the equipment. Right. But this piece of, we want to reform the tort so there's less liability, but we also need to, in my opinion, simultaneously say, okay, well, if we're going to make tort reform as a priority, we should make sure that the motor carriers are safe, and we should make sure that the insurance they carry is the amount necessary. And whether it's 2 million or 3 million, I'd love to see a mandate for $1 million general liability policy with a $4 million umbrella policy. It would probably put a lot of motor carriers out of the business. Yeah. But that's probably not a bad thing.
And most shippers and brokers nowadays require $1 million of insurance, regardless of whether you're hauling hazmat or not. So, to even get business from a lot of the shippers and brokers, if that's where you get your business, you're gonna have to have $1 million anyway. So mandating that doesn't seem to be a heavy lift. The excess insurance may be the problem, because there's currently no requirement for any excess insurance. But yeah, we'll have to see. And then in terms of the maintenance, another thing to consider that we haven't even talked about though is the increasing or how much more scrutiny we will need to place on maintenance as we start to move into autonomous vehicles.
This is one of the things I find. Yeah, I'll let you continue. But I 1,000,000% agree with you. Yeah. Autonomous vehicles will change the paradigm of how we view the safety and maintenance of a commercial vehicle.
Yeah, because you're right. I mean, right now the focus is clearly on the driver side of things and making sure that the drivers are qualified and that they have a valid med card and that they have, the right license type and that type of stuff. And certainly less of an emphasis on vehicle maintenance. But then as we move towards autonomous trucking, then the script gets flipped, right? Because we no longer have a driver in the cab of the vehicle. And so the primary safety related concern is going to be maintenance, in addition to things like, data security and that type of, cyber security. But vehicle maintenance is going to play a huge role, I think, when that comes to be.
I usually don't toss up the comments, but Saheem's got a comment here saying, this is scary though. Okay, maybe not scary, but, and I want to say, I think you're exactly right. The thing that will change about autonomous vehicles is, one, they are an eventuality. They are not a what if. I mean, we know the
Yeah.
FMCSA is thinking carefully around level 4, which is remote operator autonomy, and level 5, which is remote assistant. And I think that autonomous vehicles will be viewed by the public not dissimilar to airlines, insofar as you cannot have an unsafe asset in circulation.
Right.
The technology must prove that it is safer than anything else. And those companies are going to require, to your point earlier, pre and post trip inspections. Who's doing that?
Yeah.
Who's going to do that? Probably a qualified mechanic. It might be expensive initially, but over time, it'll still be cheaper than the driver in the vehicle going back and forth.
Right.
So in my mind, I think that autonomous vehicles will force us as an industry to be safer on our equipment. And we tried to make our industry safe voluntarily, because I think one inspection a year is not robust in any meaningful sense. So I think you're right. I think when autonomous vehicles arrive, how we maintain them and how we deploy them will be paramount, will be safety, because we assume the efficiency is going to be there, but the repair and maintenance, that's going to be encouraging.
Yeah, we've already seen FMCSA, as you said, they've already been thinking about autonomous trucking, thinking forward to that and what they need to do in terms of revisions to their regulations. We've seen them come out with an ANPRM in the past on this, asking these types of questions that we're talking about now. What about maintenance? What do we need to do about pre and post trip inspections? What do we need to do about the people back at the office that are, dispatching these trucks? Do
The
they
drone operators, what's the qualification for them?
Exactly. Yeah. Do they need to be subject to drug and alcohol testing and that type of stuff? So all of these things are going to have to be ironed out over time. But you're right, it's coming pretty quickly. I know operators out there now that are currently out on public highways operating these autonomous trucks. And so it's here.
As John Radvansky notes here, he's seeing them in Texas between Houston and Dallas. Yeah, those trucks are running. Now, they're in many cases, they have a safety driver.
Yep.
But that safety driver is not necessarily intervening. And that's
it's usually an engineer that's sitting in the passenger seat running the data on the tablet or whatever. But yeah,
it's going to be, I think, like, this will be the next iteration of what the Motor Carrier Act of 1980 did. It was the rise of the independent contractors, the fragmentation, and autonomous will kind of finish the work of the movement away from W-2 employees. Now, I think that's still a ways off, but once the regs are in place, it doesn't stop. It just goes. It just goes. And you have to, in advance, be like, okay, well, what are we going to anticipate? What's the challenges? And I think, to your point earlier, it's going to be human beings inspecting these vehicles far more rigorously and more often than we do today, because the sensor may say everything's fine, but sensors are just sensors.
Who's checking the sensors?
Exactly. You can't automate the mechanics, not yet. So we'll have humans fix the robots, and then we'll go from there. But now I want to segue, because you talked about Chevron earlier. Now I have to explain to everybody who's watching briefly.
I'm going to go take a nap while you do this.
I am so sorry, but right now you're going to learn about one of the most nuanced and complicated aspects of law in the country. We call it administrative law. Administrative law is essentially a subset of, just general statutory law, where the federal government, through Congress and an assigned signature by the president, creates an administrative agency. That agency then promulgates rules, creates rules that have the same force and effect as statutory law, but they're kind of created by the experts. And what we saw just a couple weeks ago was the overturning of this thing called the Chevron doctrine and the Chevron deference. And this case, Loper-Bright, in my opinion, I'd love to get your thoughts on it, is probably the most important and significant Supreme Court case in my lifetime. I think that we, over the next few months and years, we'll kind of learn more about it. But initial reaction, Loper-Bright, what do you think?
Yeah, I don't know. That Roe v. Wade overturning may rank up there pretty high too. But from our perspective, certainly working in a very heavily regulated industry, it's probably the most important decision in our lifetime. And it takes me back to administrative law in law school, a place I don't really want to go back to, frankly. And I'm certainly no constitutional scholar. And this, when we're talking about these things, it also has some politics wrapped up into it. And I'm not all that interested in talking about politics. But from my perspective, my opinion, for what it's worth, which is not a lot, I think it's probably a move in the right direction. I think, in my personal opinion, I think we've gotten a little too far afield from the way that the Constitution envisioned us doing lawmaking or passing, laws in this country. Clearly, it was intended that the Congress was to do that, was to be the rulemaking, the lawmaking body, and it made sense to do it that way because they were the ones that are the most accountable to the people, right? Yep. We elect new Congress folks every couple of years, and if we don't like the laws that they're passing, we can get them out of the office and replaced pretty quickly. Whereas the other branches is not so much the case. And so the problem that a lot of folks have with the way that we have set this up is that Congress has gotten to a place now where they are passing very generic laws, and then they are delegating their rulemaking authority to these thousands of alphabet agencies that have been set up that are ostensibly part of the executive branch. They are supposed to be implementing and enforcing the laws, I think, was the original design, not so much creating the laws themselves.
Yeah.
I understand how we got here. As you mentioned, these, in most cases, these are the experts at these agencies that should know more about the topics that they're regulating than anybody else in the country. At the same time, a lot of these folks are unelected, and it goes back to that accountability thing. If we don't like the rules that the FMCSA is passing, what's our recourse? We don't elect those folks to be put into their positions at the FMCSA. So, I think deferring to these agencies when it comes to their own interpretation of their statutory authority, what the Congress has given them, why would we defer to an agency to do that other than our supposed reliance on their expertise? I think getting rid of the Chevron deference makes sense. And, it's obviously, it could create more work for the Congress, which I don't know is a bad thing. They're going to have to be more cognizant, certainly going forward, of the laws they pass and probably being more specific in the laws that they pass. Again, I don't think that's necessarily a bad thing, but recognizing that they may end up in the law may end up in court, and then the court that's reviewing it, now that Chevron is no longer a thing, won't have to defer to the agency's expertise necessarily in terms of deciding whether that the agency's implementation of those laws was lawful or not. So, long way of saying, I think it's probably a move in the right direction. I understand the arguments against it, but overall, I'm generally in favor of it.
I think your point on Roe is really well taken. I think Roe is this really interesting case of people they don't realize it's based off of Griswold and this kind of penumbra with an umbrella and the shadows and where the rights come from. But at the core, they're actually fairly similar. The Chevron deference and Roe are similar in the sense of there were Supreme Court justices that looked into their belly buttons and said, I think the law is this. And we're going to create something from whole cloth. We're not going to have this grounded by statute, by Congress. We're going to opine that we think this is the right way. And for people who have asked me, and I've talked a lot about Chevron, the example I like to give, and you remember this case very well, when OSHA tried to mandate vaccinations, and OSHA looked at their enabling statute and said, well, we think we have the power for that. It's like going to your son and saying, hey, what time should your bedtime be? You make the rule. I trust you're the expert in what you do.
And we'll defer to you. Yeah,
exactly. And it's interesting. These agencies, for what it's worth, generally don't say, I don't have the power to do this. They generally say, I have a lot of power and I haven't even begun to use my power. And I think Chevron deference, this was the case, this thing. The U.S. Chamber of Commerce fought that more viciously than any regulation that had ever happened. They fought this because the idea of a regulator getting to make its own rules and interpret its own statute pulled a lot of power from the federal judiciary. So I think, to your point, I think the outcome is probably correct. I think Chevron, if they love it so much, you can make a statute. Like you could still do it. It's not like it's over. But I don't think they will. No. And Congress people.
And the other side of the coin is, there's a lot of folks saying, well, that's going to flood the courts with litigation and all these
Good for
cases.
the lawyers. We need more work.
Yeah. I don't think, it's a parade of horribles, right? All the things that could happen that probably never will happen. Maybe we'll see some uptick in the litigation, calling to task some of these agency decisions, but good. Let's put it to the courts to decide whether the agencies acted in accordance with their enabling statutes. Why would you ask your kid what time they should go to bed? To your point, you are the parent. Congress is the one. Congress is the one that makes the laws. The judiciary is the one that ultimately decides whether the laws are constitutional or not. And that's ultimately our checks and balances. That's the system that we have. That's the way it's intended to work. Now we're just talking when we're getting into Chevron. We're just talking about moving the needle from one to the other a little bit. Who's going to have to do more work than the other one now? It was the agency doing all the work. The court could put their hands up and say Chevron deference. Now the courts are probably going to have to do a little bit more work to get themselves up to speed on what these laws mean and get themselves a little more expertise on the topics that they're weighing in on. But ultimately, we should drive the work back to Congress. They're the ones that are accountable to the voting public. They're the ones that should be passing laws with specificity so that if that's the will of the people, then those are the laws that get passed.
Yeah. I think from our perspective on the trucking side, we may see potential litigation around the emission standards by the EPA. I think that's going to be challenged under the Chevron, going away. ELDs, probably not, because Congress actually said you need to do ELDs. That was a 2012 thing. I would say, like, in the case that upheld ELDs eventually in the in Seventh Circuit Court of Appeals, they did rely on Chevron.
I couldn't remember if they relied on Chevron deference.
They did on the harassment piece. So the word harassment was there, but no one had interpreted it. So there is a question, I think, that could be raised. And OIDA, if anyone brings it, it would likely be them. We'll see if speed regulators get in that mix. I could see there being a challenge. I would say, backing up a little bit further, now that Chevron's gone, it will incentivize anybody who disagrees with any federal rule to sue, because you have a better chance now than you ever have in the last 40 some odd years. Best chance you could ever have.
Yeah, I mean, that could happen, but it's not a cheap prospect to litigate those cases. I mean, it's going to be the interest groups that are well funded that are going to be the ones that are challenging it, and if they got the money to do it and they want to waste their money doing it in situations where it's very clearly within the agency's statutory authority, then have at it. Lose your money doing that. But that's the other thing to keep in mind. I hear a lot of folks saying, well, every rule is going to be challenged. Well, no, not necessarily. I mean, there is a limit to this. The agencies are still entitled to act within the authority that they have been specifically granted by Congress. And if it's very clear that Congress told them to do something and they just did what Congress told them, then I don't see really any reasonable basis for them to challenge it.
Do you think the autonomous vehicle space is something that will be subject to this? Because I've been trying to think about this question, like FMCSA for sure, regulating safety on the motor carrier side. Do you think they have the authority to regulate autonomous vehicles? Would they need Congress to step in and say, hey, this new subset of assets that are going to come into the world, we're going to need to give you additional authority? Do you see that
question. I don't know. I haven't really thought about that. I haven't looked closely enough at the statutory mandates in a while from Congress to the US DOT to see. I'm sure right now they are very broad in that sense, and so FMCSA, if they were to come out with autonomous specific regulations, that they would have to obviously cite some kind of congressional authority to do that. So I just don't recall what the specifics are in terms of that. So I don't know. Maybe it could. And there, I would imagine that if it's anybody that's going to be challenging that, it's probably going to be the manufacturers of the autonomous equipment and stuff like that.
Absolutely.
But we'll just have to wait and see.
I just hope there's no self-certification of autonomous vehicles. Like, that would be I don't want that. Whatever happens, I don't want that.
Yeah, exactly. Yeah.
Well, we're getting close on time here. I know you have a boot camp coming up. Tell me a little bit more. What are you doing? Because there's a whole bunch of stuff we haven't even talked about, e-logs and other things you're working on. So give me a heads up. What do you have coming on in the pipeline relatively soon?
Yeah, we do what we call our fleet compliance boot camp a couple times a year. We did one in Orlando late last year, and now we've got one coming up in Indianapolis in September 25th and 26th. It's a 2-day in-person conference where we dig deep into DOT regulations, FMCSA regulations, driver qualification, vehicle maintenance, everything we've talked about today. We spend a lot of time digging deep and helping fleets to make sure that they understand the basics and that they start to build out effective programs back home to keep our roadways safe. That's ultimately the name of the game. And so we do that through our boot camp. And so anybody that's interested in joining us for that, we usually have, 60 to 70 fleet safety professionals in attendance. It's a great networking opportunity. We've got a lot of vendors that are going to be there. So we'd love to have you join us there. Details over at trucksafebootcamp.com.
I will make sure to put that in the show notes here. Now, one thing I'm gonna advocate that you haven't said. I'm gonna force this issue. The time to work with Trucksafe is not when you're under intervention. Now you can, but it's really about being proactive and understanding like what your policies and practices are, how you can improve. And I liken it back to doing a PM on a truck. You do the preventative maintenance inspection to catch the brakes, lights, and tires, the BLTs as they were.
Yeah.
But it's important to be involved early on. Is that right?
It's critically important because by the time if you're calling us and telling us, hey, the DOT's here at our office, they're doing an audit. Can you help us? It's like, yeah, I could sit in that audit, but there's not much you can do at this point. They're looking for historical violations in your records. We're not going to go back and falsify a bunch of records as if the violations didn't exist in the past. That's going to get you in more trouble. So by the time you're already in it, same holds true with serious accidents. I mean, there's some stuff you can do after the fact, but not much. And so, yeah, it does you very little good to hire somebody to help out after the fact, after you find yourself in these situations. That's why it's important, the things we already talked about, watching your safety metrics, looking for trends in your data. You don't necessarily need us to do that. You could do it yourself, but if you want some help figuring out how to do that, what are other, industry leading fleets doing in that regard? That's the type of experience and knowledge I think we bring to the equation. And that's the stuff we love working with fleets on, are the ones that are interested in being proactive with this stuff and keeping out of the crosshairs to begin with.
I couldn't put a better way to frame that up. This is maintaining your equipment, maintaining your company by working with someone who's worked with the best in the world to do just that. So there's safety never goes out of season. It's something that we should always be kind of focusing on. Yeah. What is eRegs? Tell me what this is. What is this all about?
eRegs is a software we spent the last couple of years building, developing. And it is a digitization, number one, of the Federal Motor Carrier Safety Regulations. Everybody's familiar with the Green Books. Everybody's probably got a copy that's listening in. I've probably got 50 copies of it in my office somewhere. It just never made sense to me that we were still doing this with these paper books. And so, first of all, I wanted to digitize this process, if nothing else, for my own convenience. But then as we got into it, it became a lot more than that. And so now eRegs is a software solution that fleets can utilize to not only read the regulations, but also interact with them in a way that's helpful to your operations. So whether it means, highlighting and bookmarking and taking notes within the regulations, but also accessing all of the content that we've developed over the years. So if I'm reading the regulation on the short haul exemption, for example, all of our videos on the short haul exemption explaining in depth how that works and how awesome. It might work for your fleet is right there alongside it, along with the DOT's guidance that they've issued on those regulations over the years. It's all baked right into that platform, which also makes it easier for fleets to share the regulations with their drivers, which is another thing that we continue to do the old way with those handing out those pocketbooks to all of our drivers. They end up in the trash so often. And so eRegs makes it easy for fleets to digitally share the regulations with their drivers right on their tablet device in their truck, on their ELD, stuff like that, so that they have access to them and can read the regulations for themselves right there in their trucks. So
that's fantastic. I mean, well, the idea is like, how do you make this stuff accessible? Like the reality is like, we expect the motor carrier and the driver to know these regs. They know them. They have to be part of them. And yet it's difficult to navigate them without having something that's more akin to modern technology. Is this like an app on the phone?
It is, yeah. So we've got a web app that the safety managers can access from their computer or their mobile device. Then we've got a driver-facing app that they can have on their mobile phone or their tablet device and read the regulations right from there. And like I said, more importantly, get access to our commentary on it so that you're not just, all of these rules are written by usually lawyers. And
the cause of and solution to all the problems in the world.
Exactly. So, that's kind of what we spent the first 3 years of Trucksafe doing, was developing content to break these things down and make them more accessible and easier to understand. So it made sense to bake that in right alongside the regulations, so you're not just left reading these dense rules, but you're given some content to help you understand what they mean.
Well, we will make sure to link all that in the show notes. Brandon, it's always a pleasure to have you. And I appreciate making time to come and talk about some of the interesting regs coming. We'll have to do this more often because we haven't even talked about freight fraud, double brokers that everyone seems to be thinking the FMCSA should get involved with. Are there any last things we should think about before we end up wrapping up for today?
No, I'm not even going to get into that because that would lead to another half hour at least. So no, I think we've covered everything we should cover today.
Well, thank you so much for stopping by. Stick around for a second, but I want to say the little quick outro to everybody. Thank you as always for tuning in. It's a great privilege to be able to break down some of the interesting things in the supply chain. It never ends. It never stops. Freight doesn't stop, and neither does Brandon Wiseman, president of Trucksafe Consulting, eRegs, and now as a lawyer with the Childress Law firm. If you think you need an attorney, you probably do. So always consult the experts. As always, thank you to my friends over at DAT, Dial a Truck. It's in the freight. Gear Up is going on right now. You've gotten some additional wonderful things. And if you're new to DAT, I have some great news for you. If you're new to DAT, whether you're a trucker or a broker, we can get you 10% off for the first 12 months. Just click the link in the show notes. As always, I appreciate you stopping by. It's a great privilege to be part of your afternoon or your evening talking about law and supply chain, two things you cannot opt out of. As always, have a great day. Thanks again. And then I click the button and it goes away.